insurance amendments, governing the boards that govern our associations, and collections enforcement. Those are the main topics that we're going to cover. I want to mention very briefly, I know this seems like it's announcement hour, very briefly, and this slide reflects it. Craig and I have been working for a very long time. Craig's been dragging me along and waiting on me, and hopefully I'm going to get my act together. But the plan is to put a program online substantially similar to what y'all have come to the last 2 Mondays. So we were having a conversation and went out on the web and looked, is there anything like this out there that we could point people to for a resource? And we couldn't find anything, interestingly enough. And that honestly is what kind of got me interested in this area of law to begin with, and why I wrote that Oklahoma handbook, which, is Johnson here? Okay, all right. I've got your handbook, by the way. Well, we're doing that now just for the 21st century. I wrote that back in the 20th century, and no, it was, I started in the 20th, I finished in the 21st. So anyway, hopefully within a few months we will start rolling out these programs, and we can tell folks more about them. But the idea is to present a lot of this information in much greater detail online and from the comfort of your home and your jammies if you want to, as opposed to showing up and listening to us. Okay, so I'm going to do just a little bit of overview, and this is kind of the same format that we did last time. I'll cover the stuff I want to cover. If y'all have a question, throw your hand up and ask, and I might get to it, or I might answer it right there, okay? So we will just fly along for the next hour and a half. So if you'll remember, if you want to look at the law in Oklahoma, go to oscn.net. There's other places you can go, but the best place is the Oklahoma State Courts Network. And this is basically the body of law that encompasses, from a statutory standpoint, meaning the statute that the legislature adopts. And now if you were to go to OSCN, there'll be a box up here. You can type 60 OS, and you don't necessarily have to put the periods, and then space 501, and that's going to take you to the first section in Oklahoma's Unit Ownership Estate Act. And if you scroll all the way to the bottom of that screen, then any case in Oklahoma that has cited to that act, there's going to be a link to the bottom, and you can click on it. You can read what that case was about. You're not going to find very many cases at the bottom of these statutes, simply because we don't have a very robust statutory or case law body for homeowner or condominium association law. So that, if you'll remember, is why it's so important that we know our governing documents and that we have good language in our governing documents. That's why one of the things we're going to talk about tonight is amending. So that's the law. Let's talk about assessments. So if it's a mandatory association, meaning you have to be a member of the association by virtue of owning property, whether it's a unit, condo unit, or a lot, townhome, whatever, if you have to be a member of the association, then that typically means you have to pay assessments. The language here can be very important. So if we're talking about different types of assessments, oftentimes you'll find this language used. We'll find annual assessments, also called periodic, maybe monthly, maybe base assessments. But this is the assessment that's passed to fund the operating budget. Everybody typically pays the same unless we have different series or villages within the neighborhood. You know, $150 a year is my HOA dues. That's what we're talking about, okay? The next one is special assessments. Now, when we start getting into these categories, it becomes very important that we look specifically at the language in our covenants. This language might be in the bylaws if we're in a condominium setting. Oftentimes, and hopefully most of the time, it's in the declaration, but you could find it in a filed set of bylaws. But a special assessment is an assessment that typically is adopted by a certain vote of the members. It could be adopted unilaterally by the board, but it goes to fund capital improvements, repairs that were unexpected. So we wake up one day and the community swimming pool needs to be resurfaced. Well, we hadn't budgeted for that. We need to raise the money, and a special assessment is often used. Now, where we have to be careful with special assessments is sometimes the language in our covenants authorizing special assessments only authorizes them for a specific purpose. So if the language says, upon the vote of 2/3 of the members, a special assessment may be adopted for that year only for the purpose of capital improvements, period. Well, that is authorizing language for a special assessment, but it also is non-authorizing for any special assessment other than a capital improvement. You see? It also disallows multi-year special assessments. And it's real common for that language for this year only to be in special assessment clauses. So we have to read it very carefully and make sure, all right, if we get to the end of the year and we just don't have enough money in our budget, well, if we have a capital improvements only special assessment, having a budget shortfall is not a capital improvement, all right? We also have the issue of oftentimes special assessments are large. And if we don't have limiting language, like it's not uncommon to have language in our special assessment clause that says you can adopt it provided the special assessment may be no or shall be no larger than 1 year and a half of annual assessments. So you basically get 1.5 times your annual assessment amount. Well, then you can adopt a larger assessment. And if it limits it to 1 year and it's a $1,000 assessment, oftentimes the conversation becomes, well, can we make payments over 2 years? Or can we just split this up? Why don't we do a $500 assessment this year and a $500 assessment next year? Well, you can do that, but you can only vote on the first year's $500 special assessment. Make sense? All right. That's where Patrick comes in. So a lot of times what I find in my practice is you get a board that comes in, particularly after a board who has not been that keen on financial matters, and they look at the budget, they look at the reserve fund, they look at the fact that we've got a $15,000 deductible to replace the roofs on all these buildings, and we have $3,000 in our checking account, and we have no savings account. And so what they decide is, you know what, as a matter of good fiscal policy, we're going to raise dues and we're going to adopt a special assessment so that we have a fully funded reserve fund to pay for a deductible or to pay for a capital improvements plan. So they submit it to the membership. The members look at that and say, absolutely not, we're not paying for this, and they vote it down. Well, the fact that the members vote it down doesn't make the problem go away. It just continues with the ostrich approach and ignores it. That's when the board may need to look at funding and going in and talking to Patrick or a lender and looking at borrowing funds. Okay? So special assessments are good things, but sometimes from a political standpoint, the members just won't adopt it, and special assessments won't work. You have to look at other funding mechanisms. Specific and individual assessments. Now, I think I mentioned it in the first one, in the first part of this series. I'll mention it again now and probably later tonight. One of the best methods of getting people to do what they promised to do when they bought into the neighborhood is fines, monetary penalties. It's one of the best ways. It avoids, typically can avoid lots of attorney's fees, lots of time in court, and it gets people's attention. But you have to have that language in your covenants. The board can't decide, hey, the lawyer said fines are great, so we've adopted a policy, we're now going to fine people and file liens. Great way to get yourself sued. You've got to have the language in your covenants, okay? Nope, not bylaws, in your covenants, okay? But if you do, it's a very effective enforcement remedy. and you follow the language in your covenants. If the covenants were well drafted, then it's going to provide some means for the board to adopt a fine schedule, to publish it to the owners, to follow a process for applying those fines, giving an owner an opportunity to challenge those fines, also known as due process, and then the ability to enforce that fine by filing a lien or taking them to court. It works. And if we follow the process correctly, we have given them all the notice, all the opportunity to comply. And as C.S. Lewis describes similar instances, you can give someone who hasn't studied for the test a test 100 times and they're going to fail it every time. Doesn't mean you're making them fail it. They have chosen it. And it's the same way with fines. Okay? Because sometimes boards will hem-haw, well, it just seems punitive, and we'll give them another chance. Give them another chance. Give them another one, and another, and another. And at some point, you have to make the decision, this person's just not going to do what they said they were going to do. And that's where enforcement comes in. You can ship the file off to a lawyer. They can charge you, if it's my firm, it'll be a $5,000 retainer before we file a lawsuit. That's a lot of money. Or you can follow a fine schedule, and perhaps before you get to that point, get the RV moved or the whatever issue resolved. That's what fines and specific individual assessments. You notice I don't put fines. I call them specific assessments, because when I stand in front of the judge, if I'm trying to collect this fine, I want the judge to hear specific assessment, not monetary penalty. Because there's a road a judge can go down and say, well, we've got Title 15, and Title 15 says monetary penalties are unenforceable unless it's liquidated damages, and they can start dragging up all of this law school stuff. What I want them to think is in terms of assessments. Assessments are things people promise to pay by virtue of being a member of an association. And we all know you got to pay your HOA dues. And I want the judge thinking, this is no different. This is just a different type of due. This is an assessment that's due because people didn't do what they said they were going to. All right, you had a question?
Okay, you mentioned that in the covenant you need to specify, allow for the means to assess a fine later on. If you don't have it specified there, can you then do an amendment?
Yes. Yes.
And take care of it there.
Yeah, we can add it, and often do. Yeah. In fact, that's on the list. When a client comes and says, hey, we need to update, modernize our covenant, that's typically on the discussion list. So reserve assessments. A reserve it's not a slush fund, it's not the money that we have left over at the end of the year. It is a purposeful savings account. So if your association owns any property, and that could be detention, retention pond, clubhouse, swimming pool, anything that you insure, then the board needs to consider a reserve fund. And a reserve is simply, how long is this thing going to last before we have to replace it? Or how long is this thing going to go until we have a major repair or need to modify or update? It could be a new improvement. How long are we going to go without a playground? And then when we decide we want the playground, how much is it going to cost us? Okay? And the same thing for the repair. Well, that process, coming to that conclusion or that information or report, is called a reserve study. It's answering the question, what do we own that we want to replace or repair? How long do we have until we get to that point? And what's that expense going to be? Once we have that information, then we can divide that number by the number of years and by the number of members. And that's our reserve assessment. So if you're in a condominium development, more than likely, hopefully, your condo docs, your declaration requires the board to have a reserve. If I get to the slide later, but anytime you come across the word shall in a contract, it's a non-delegable duty. It's a non-discretionary duty. It means you have to do it. So if your covenants provide, the board shall on an annual basis establish a reserve and collect it from the members, you got to do it. You can't just think, well, that's just more legalese, we're going to ignore that. Nope. It serves a very important purpose. Okay? Even if your condo or your homeowner association docs don't provide for a reserve, if your association has a swimming pool and a clubhouse and a detention pond, all of those things, if you have private roads, you've got to have a reserve. If you have a $5,000, $10,000, $15,000 or more dollar deductible for your association insurance policy, how are you going to access that insurance money if you have a casualty and you don't have that money ready to pay? Okay? So that's what a reserve is. And I put on here CAIRF. CAIRF stands for Community Associations Institute. Oh no. Patrick, you're the CAI member.
Yeah, it's supposed to be, I think the F's not the right letter.
F is foundation. What's the R? Research. Sorry.
Foundation,
Goodness. We've all hit that age where we're all just... Community Association Research Foundation. So if you go to www.cairf.org, there will be something called Best Practices Reports. That's what that BPR is, Best Practices Reports. And there's one on reserves. If your association is nearing or in the process of going through transition, meaning your developer or declarant is in control and they're looking at handing it over to the members, there's a best practices report on transition. So there's a number of them, and they're really good and they're free. PDFs, you can just download them. Okay. I'm not going to go through these line by line just from time standpoint, and you can probably get the gist of them. But I'll tell you, when I stand in court or my law partner stands in court collecting assessments, particularly in Oklahoma County, we don't necessarily see this in other counties, but the small claims judges in Oklahoma County sometimes will get twisted up about notice. Now, the notice that they're talking about is they seem to find some sense of injustice if a piece of paper hasn't been mailed or emailed to the individual owner. Now, I get that if the covenants themselves say the association on an annual basis shall send notice of the assessment, but not all covenants will provide that. Now, whether or not your covenants do provide that, it's a great idea. The association has to demonstrate that it's following not only the covenants but also good business practices, and having individual account statements, even if they're handwritten ledgers, which I still have some of those come in occasionally, but finding an Excel spreadsheet or use QuickBooks, hire a manager and have them use their management software, having the ability to track down to the penny what is being charged is very, very important. It's not only important for notice purposes, but it's also if you're having to defend a counterclaim, or at least a defense from the owner that says, I don't know this, the judge is going to then look at the attorney or the association and say, can you prove that they owe this specific amount? How do you get to this number? And if your number's a mess, you're not going to have a successful day in court. So having systems in place, software in place, doing the same thing over and over again, it's not boring, it's liberating. It's having rules to the game, because if you don't have rules to the game, it's chaos. At least it is in collections, right? So that's what I'm talking about with procedure. I have an entire other screen on collections, so I'm going to skip those last two. But let's talk about collecting assessments. I harped on this a little bit last week. I'll continue the harping this week. Collection starts before that person becomes a member of the association. So having systems in place where you're providing a piece of paper, a notice, a welcome to the neighborhood, that's collections. It's like preventative medicine. You know, if you don't get sick in the first place, you don't have to worry about the medicine you take. Well, if this person cuts a check, routinely, if they have enough customer satisfaction that even if they don't like everything that's going on, they're still going to support the association, and at least they're not going to withhold their money, then you don't ever have a collections action. You don't need to send it to the lawyer or send it to the management company. So to the extent you can provide, as best the association can, good customer service, then that's the best collection dollar you can spend. It's the cheapest. The next would be having processes in place, like I talked about, checklists, resolutions, knowing what the governing documents say. And I'll give you a really good example. One of the first things that we scrutinize, I'll give you a handful of things that we scrutinize, because when the file comes into our office, we are a third-party debt collector, which means the Fair Debt Collections Practices Act applies to us. And I am scared to death of very few things in this world. The FDCPA is one of them, right? Don't fear guns and bombs. I fear the FDCPA because it's so easy to violate it. What the FDCPA is, the Fair Debt Collections Practices Act. And one of those things in the FDCPA is we can't collect illegal debt. Well, what's illegal debt? Well, it's made up debt. It's non-existent debt. So it has to be a real debt. Another part is you can't use techniques that are considered gross, immoral, dishonest. That's the classic. You call someone and you tell them, I'm going to put one of your family members in jail if you don't pay this debt, which is laughable, but it works on a certain segment of our population. And debt collectors still use them. Not this debt collector. So you can't do that kind of stuff. Well, one of the things that we scrutinize when the file comes in is this a real debt? I want to look at the accounting. I want an account statement that goes back to zero. I want to see that we're collecting a debt that's not limited by the statute of limitations, which is 5 years in Oklahoma for a written contract. I want to see if a file comes in and I know your assessments are $150 and you're trying to collect a $7,000 debt, immediately the question becomes, how in the world does this debt become $7,000? And the response sometimes from the client is, well, they haven't paid in 10 years. Well, guess what? We're only collecting 5 years worth because you can't collect the rest of it. It's barred by statute of limitations. Another thing that we're looking for on the account statement is the appropriate use of interest. A lot of times declarations will provide for a certain amount of interest. Amazingly, the bylaws will provide a different amount of interest. So for example, the declaration provides 10% per annum, but the bylaws, they decided, oh, why stop at 10? Let's go to 18. Well, guess which percentage rate the account statement uses? It's 18. Well, the first thing that debtor or their lawyer is going to say is, why are you charging 18? The declaration only charges 10. That is, I don't know if they would ultimately prevail, but that's a potential FDCPA claim. So we're going to skip that. We're going to require the lower amount. The easiest way for your association to violate FDCPA, and I see this all the time and I see it routinely from management companies, is this $25 late fee. Where does that $25 late fee come? Because we see it on the account statement, and that's the first question. All right, show me where in the governing documents this person agreed to pay a $25 late fee. Well, they didn't. We just feel like they should pay extra if they don't pay on time. Well, I feel like they should pay $100. Why stop at $25? It's just made up debt. I can't collect that. That is an FDCPA violation. That is the equivalent of saying, I'm going to put grandma in jail if you don't pay this debt. Okay? Law treats it the same way. Yes, ma'am?
You can't collect it if it's not in the CCR.
That's correct.
It has to be in the CCR.
That's right. Has to be in the CCRs. I have found CCRs that provide for late interest plus a $25 fee. We will try to collect that, but if that case goes to court, there is a high chance that the court's not going to award that anyway. And that's just what you get in small claims court sometimes.
Why is that?
Because the judge doesn't like it. And they're the ones who make the decision. So the economics are such with small claims judges that they know it's going to cost about $4,000 for an appeal. And most of the time what we're collecting is $2,000, $3,000 in small claims court. In 20 years, I've never had a client say, yeah, let's take them up on appeal. They just know you're not going to do it. Not for $25 or $150, whatever it is. So it's just an economics game. So it's very important that the numbers look right.
Get this.
So let's talk about lien practice and then going to court for collections. I had a conversation with a manager in Tulsa, I guess it was last Thursday or Friday. We were talking about FDCPA, and it's amazing to me how few managers even think about FDCPA. And I was talking about liens, and I said, you know, I still find managers filing liens, and she screamed into the phone, and she said, I signed a lien yesterday, what are you talking about? And I said, what? Show me in the governing documents where a manager has authority to file a lien against someone else's property. You know, and she starts freaking out. Well, and I told her the same thing I'm telling you. Well, don't freak out. As a young lawyer, I signed liens too. Well, you know, the theory goes, well, we're agents. Of course we can file them. Well, until someone files an FDCPA claim and walks the judge through, there's no authority here. So you have to know what the authority for filing liens is. And the first place is your covenants have to allow the filing of a lien. Just like fines, it does not follow just because your association means you get to file a lien. Just because you're an association doesn't mean you get to file or get to claim fines. The language has to be in the covenants. And so sometimes that covenant language says an officer shall sign and file the lien. Well, officer is not necessarily board member. And these are the things that lawyers look for, particularly lawyers looking to hold people liable for the FDCPA. So you got to know the language. And this is why I think having resolutions, corporate resolutions dealing with routine activities like collections, you just spell it out. So the board gets around or the officers get around your declaration, you read the assessment language, and if it says assessment shall be sent out no later than January 1st and are delinquent 30 days thereafter, then your collections resolution provides no later than January 1st, we send out a written statement or an invoice. They're delinquent after 30 days, and then you just follow whatever the language is. This also helps in decision making. If you want leniency, if you want to build in mercy in your collections, then do it. But what you can't do is get to pick the winners and the losers. You don't get to pick, okay, this story sounds legitimate and sounds sad enough, we're going to give them a buy or we're going to let them pay it out. This person, they're really pushy and they ask a lot of questions and we're not really familiar with, you know, their family. So, no, they're going to pay in full 100%. That's the case that gets the association in trouble. Okay? With a collections resolution, look, this may seem impersonal, but we have to follow the resolution. And so this is the next step. All right? And we're not executing pets here. We are asking people to do what they said they were going to do. Now, everyone picks and chooses which creditors they pay at some point in their life. If you've never had to do that, well, bless your heart. You've led a privileged life. But most of us have at some point. I'm going to pay this one because I can't pay both of them. And oftentimes the association is the one on the low end of the totem pole. And that's fine, I get it. That doesn't discharge the obligation, but it does put it into some context. And so for those board members that it's, 100% all the time right now, we may need to counsel them to just cool your jets a little bit and follow a procedure that makes economic sense. Part of that is taking payment plans, okay? It's going to cost you at least $100 to ship the file to my office, $300 if you want us to send a demand letter and file a lien, okay? Well, that's just another $300 that gets tacked onto that person's account. If you can offer them a payment plan that saves them $300, do it, and don't send the file to our office. Okay, so just think about that in terms ahead of time. What does our checklist look like? I told you about Atul Gawande. Did anybody go look up Atul Gawande after last week?
I know it.
Oh yeah.
I put the book, but I haven't read it yet.
All right. Well, they have it. They have it on audio in the Metropolitan Library System, so you can listen to it. You don't even have to read it. This is another good example of why checklists work really well. All right, so in the event you file the lien, you send the demand letter, and nobody pays attention, then the next step would be to just sit on the lien and hope that they close or refinance their property, because what's going to happen in that process is a title company is going to find the lien and require a payoff. Okay. The other alternative is to foreclose on the lien, which you can in Oklahoma. And so when your individual owner says, I'm not paying, you can file the lien, you're going to have to wait till I sell the property. The response is, actually, you need to fact check that because the truth is, in Oklahoma, you can have your house sold out from underneath you at a sheriff's sale for not paying your HOA dues. Now, the likelihood of that happening is possibly low, but it is possible. Yes, ma'am?
If you file the lien and you go to the point where you want to do a foreclosure, and there's a first mortgage on the place, you're under that mortgage on you.
Exactly, that's right. Yep, it's a first in time, and you can almost guarantee that the association, if there is a mortgage company, that the association will be junior, meaning second in time to them.
What else are we junior to?
It's just a filing. It's the date of filing. And you're junior to the purchase money mortgage because at the time of closing, the closing company's job is to make sure there's no dues owed. So if there was a lien, that gets paid, then the mortgage gets filed, and they have first priority. Then after the first year, they don't pay their dues, and now the association lien gets filed. Well, then say they have a roofing company come do a job, and the roofing company comes and files a lien. Well, mortgage company is going to get paid first, association gets paid next, and then a roofing company is third. It is. That's right. Yeah. We don't do many foreclosures in single-family homeowner association settings because the dues are typically $250, $300, something like that. After 5 years, the economics just aren't such that you'll file a foreclosure. Foreclosures are relatively expensive compared to trying to collect money judgments. The alternative is to file in small claims court, which the jurisdictional limit is $10,000 for small claims. Or you can file what's called...
Does that mean jurisdictional limit? What's that mean?
It means your claim can't be more than $10,000 to bring it in small claims court. There is another lawsuit up to $10,000 called a CS case, civil special. We don't have enough time to go into the reasons why you would choose CS versus SC, but there are different considerations, and so you may want to file in one over another.
Can I ask you a question?
Of course.
You said back on in the CCR, it has to say that an officer shall file a lien. It doesn't say an officer can file a lien.
More than likely what it says is the association is authorized to file a lien. It may even say that upon delinquency, there shall be a lien or a charge on the land. Now, some associations will take the position, well, the covenants themselves say that it's an automatic lien. That's true, but you should still go ahead and file a lien because that's what the title company's looking for. Very few title companies are going to consider that language a lien. They may still go ahead and contact the association to see if any dues are owed, but I would go ahead and file a separate lien calling out that debt.
But the officers can do that. The officers can do that if it doesn't, even if it doesn't say that in there.
If it says the association, then typically a board member or an officer can do that.
You said that earlier, okay.
Now, my example was if the covenants say an officer shall, or if it says something like the president shall, well, that's very specific. If it says the president shall sign and file the lien, well, president is not secretary unless it's president-secretary. And that's very, very narrow language.
What does a lien actually do?
That's a really good question because some people think a lien does something other than give notice that there is a debt owed. All the lien does is provide evidence of a debt. The lien is not the debt. And because sometimes I'll hear, okay, well, there's a 5-year statute of limitations, we'll just refile our lien. Well, you're refiling a lien to give evidence of the exact same debt. Filing the lien doesn't do anything with statute of limitations. It doesn't, you definitely don't go file your lien if you get notice of a bankruptcy. That's a violation of federal law as well. The lien is simply an evidence that there is a claim owed.
Okay, so it's not, it doesn't make payment of the debt. It's just, like you said, it's not like garnishing an account.
No.
It's not actually collecting money itself.
That's right.
Okay.
It will jam up the sale of real property, and that's partly why it's beneficial. Is if they try to refinance or sell their property, it will cause a catch in that process. Just like you mentioned, a garnishment, whether it's a wage or a bank garnishment, that's a process under the law to catch that process or that transaction. So if we have a wage garnishment, it will catch my paycheck and pull it. The lien kind of works substantially similar in a real estate transaction.
Okay, if a property has a lien filed against it, if the person goes to try to to actually sell the property, then if the sale is done, first off, the lien is paid off?
Well, the first mortgage will get paid off.
First mortgage and then the lien.
That's correct. Yep.
Question.
Yes,
So the
ma'am.
dollar amount on the lien is really not that important, it's just the fact that you're filing the lien.
Well, it is important, at least on the date of filing,
On the date of filing.
because, and this is something important too, so I see liens that are filed every year for basically the same debt, or the same debt plus another year. Well, you don't have to do that. You just file one lien that says, this lien secures this amount that's presently owed, plus all future accruing interest, unpaid assessments, costs, and attorney's fees.
Okay, but like, we have a lien that's a home loan, and it's like 8 years, okay, so that they owe HOA dues on, they haven't paid. So when they get ready to sell, they'll contact we use a management company also. We'll contact the management company, or I don't know, whoever it is, and they'll find out what the actual cost is that they owe 4 or 5 years only, right?
Hopefully so.
Okay, so if by chance they cost them, they say, okay, this is what they owe, and it's 8 years worth of due, and they make them pay that, are we liable?
Okay, so it depends on who is providing that answer. Well, thank you, ma'am. If the management company says there's 8 years of dues owed and that's the amount we're collecting, that violates the FDCPA because they, just like us, are third-party debt collectors.
Okay.
If the association is collecting its own account, y'all are the creditor, y'all are not debt collectors. And I hate this because what it sounds like I'm saying is, wink, wink, we want the association, the creditor, to try to collect the 8 years as opposed to us who can only collect the 5. I don't know if that would work or not, but what I do know is that the creditor collecting its own debt is not subject to the FDCPA like we are. Oftentimes, what will happen is if you're trying to collect 8 years and you have a savvy defendant or a savvy debtor, their response is, you can only collect 5 years, this is barred by statute of limitations, and you accept 5 anyway. In years past, I've collected dues that were 12 years old, but that's unusual and not a good business practice. Yes.
If you file a lien and then they file bankruptcy, you're okay. You didn't file after bankruptcy.
Okay, we've covered this. That one. All right, let's talk about bankruptcy. And I just realized I sprang forward, but my watch did not. Okay, let's talk about bankruptcy.
You're still not going to get paid because they filed bankruptcy.
There's a couple of things that I hear occasionally, and that's, well, they file bankruptcy, so we write it off, or we've been served with a notice of foreclosure, we just write it off. Now, that is true sometimes, but it's not necessarily true. Associations can still get paid in foreclosure, and associations can still get paid in bankruptcy. Now, probably the best case I've been involved in a bankruptcy was a guy out in Canadian County, got a burr under his saddle with the association, and it was like I think an $1,100 debt. When it was all said and done, after he had filed for bankruptcy, because apparently some lawyer told him he could wipe the debt in bankruptcy, he ended up paying the association about $16,000, and most of that was attorney's fees. We collected absolutely every single dime from this guy, and unfortunately I think he got really bad legal advice. And that bad legal advice was, you can file for bankruptcy and wipe the association's lien clean off and you won't have to pay it. That's not true. It is true that the association may have to pay an attorney a whole lot of money to go after it, because it's not just a walk in the park to, hey, bankruptcy trustee, they owe us money, now pay us. You do have to go after it. But it doesn't get wiped. Now, what happens in bankruptcy, and this is why I said a moment ago, if you get a notice of bankruptcy, don't run out and do anything. Don't send them a demand letter, don't send them a text, an email, absolutely don't file a lien, don't do anything. Because when somebody files for bankruptcy, what they get is really the last vestige of mercy and grace that's built into our judicial system, and that's called the automatic stay. And what that automatic stay says and does is it keeps people like me, people like you, that are owed money from going after them for a period of time. It gives them a breath of relief for a moment. And so we basically have to hold our horses. We can't file liens, we can't send demand letters. Now, what we can go in and do is ask the bankruptcy trustee to lift the automatic stay, or the bankruptcy court rather, to lift the automatic stay and let us go after them. And if we have a lien and we want to foreclose that lien, just like the mortgage company, it's routine that someone will file bankruptcy to stall a foreclosure action. The mortgage company will send the attorney into the bankruptcy court, ask for the stay to be lifted, and then we'll be back in state court and the foreclosure will be on. That's a very routine thing, and the association can do the same. Now, depending on the type of bankruptcy, if it's a reorganization, then the association may need to file a proof of claim, some kind of notice with the bankruptcy court, and you'll get part of the plan and you'll get periodic payments. And so the answer there is you will get paid, it's just over perhaps an extended period of time. And then the question is, all right, look, if this person files bankruptcy and owes the association $150, just write it off. Don't send the file to my office. It's going to cost you multiples of that for me to go to bankruptcy court to get the stay lifted. It doesn't make economic sense to do that. I mean, we will if you tell us to, but it's going to cost you more. So foreclosures. On a foreclosure, what happens is the association's going to get sued just like every other lien holder. You're going to get served with a petition and summons. It's nothing to worry about. You didn't do anything wrong. It's a title curative process. You got to name everybody that has a claim. So if they were in an accident and they didn't pay their chiropractor files a lien, that chiropractor is going to be a party to the lawsuit just like the association, okay? So with that lawsuit, the association would need to file an entry of appearance and an answer, and typically what's called a cross-claim. Cross-claim means plaintiff, mortgage company, we don't have any beef with you. In fact, we recognize that you're senior, you're first priority, but we do have a cross-claim against the other defendant because they owe us money. And what you're going to do is the lender's going to do all the work. They're going to pay all the money, and for the filing fees, the service fees, the publication fees, they're going to get it set for sheriff's sale. And then after sheriff's sale, the association's going to look, and if there's any money left over after paying the plaintiff's claim and their lawyer, all the abstracting fees and all of that, if there's money left over from the sale, then the association may have a shot at it. Okay? So it's really an equity deal.
That's pretty unlikely though, isn't it?
It really depends. It depends on what's going on in the market. From 2007 to 2010, it was very unlikely that the association was going to get any money because all those people, all their balloons had popped, and their 120% mortgages, which were first, I mean, there's no equity in the property and people are just walking away from houses. But it really depends. So it's an economics game. So if the association doesn't get paid out of the sheriff's sale, the association can still get a personal judgment against the individual. Now, so you get two bites at the apple, one from the real estate, the other from the individual. Now, in the event, and this is a long way to get to the answer, the instance when you're never going to collect from this person. If they go through a foreclosure and there's not money in the property to pay the association, and you get a personal judgment against them and then they file bankruptcy, you're done. Cannot collect that debt. If there's a finish, this is kind of how we evaluate it. If there's a bankruptcy, but there's sufficient equity in the property, then the association may want to stick with it because they'll get paid out of the property. If there's no equity in the property, and this person is still employed in the area, isn't going to file for bankruptcy, maybe you want to go after it. But if there's a foreclosure and a personal bankruptcy and there's insufficient equity in the property, that's a dead file. You need to write it off and move along. Yes, sir.
My association, I was served, as a president, I was served with the notices you talked about on 2 foreclosures this year, or pending foreclosures, and I communicated with the attorney that I got that notice from, and just told them we had liens filed on both of those properties. We told them what the amount of the lien was, and that I'd like to have the association be recognized in the decision by the judge, which they agreed to put that in there.
Yeah.
Fortunately, both of those cases, they did not go all the way to foreclosure, and we've since been paid on both of them. May have been lucky, but
no, that's how you work them.
there was another case where previous president got the notice, and he just filed away and didn't do anything until I took over, and I saw that. By then, it was too late.
Yeah.
We couldn't do anything.
Yeah, from the date of getting served those initial papers, the petition and summons, you have 20 days to enter an appearance, and if you enter an appearance, you get an additional 20 days to file your answer. So there is a time limit. But what you described, calling the plaintiff's lawyer, that's often what I do, is I'll contact the plaintiff's lawyer, we'll go ahead and get our answering and cross-claim on file, but the rigid deadlines that you're supposed to follow in other cases, the plaintiff's lawyers are so much more concerned with getting service and making sure they do their publication right. They really don't care about the association, and they work well with most associations, whether it's the lawyer or the officer.
The only reason I mentioned that is if you're owed money, it's worth a shot to try to get your name in that process. So
It is.
you stand a chance of getting it.
Yeah.
As you said, if they owe us $450, I mean, if they don't voluntarily pay, realistically, there's not much we can do about that. It's just going to cost too much.
That's the thing with collections, and in fact we have a collections memo that we send to clients and managers, because it's the same questions. How much is it going to cost? Are we going to get our money back? And I can tell you roughly what it's going to cost, and we provide that schedule, but I'd be lying to you if I told you, yes, you're going to get your money back, or no, you're not. I simply don't know. I mean, it's one of those roads. We don't know what the end of the road looks like until you walk the road and take a look. And it's entirely possible you spend a whole lot of money and you don't collect anything, and you've wasted your time and money. It's possible, like poor Tyson Doherty out in Canadian County. We went a long road and he ended up paying a whole lot of money. So it really just depends. All right. Yes.
Under assessment liens, you said not MMLs. What is MML?
Yes, thank you. So MML is I'll go back. That stands for Mechanic, Materialman, and Laborers liens. MMLs, we call them MMLs for short. This type of lien is a different type of lien than what your association files. The lien your association files is like a mortgage. It's a statutory lien like a mortgage. An MML is if roofer comes out, gave me the proper notice, I decide I'm not going to pay, then they file their lien. That kind of lien has to be foreclosed within 1 year. Your lien does not, the association's lien. Okay? Very, very significant difference. All right. Yes, ma'am.
One more. So you said if we file the lien at any time, we don't have to refile, there's no, even if it's past the 5 years, we don't have to refile that lien if they don't pay it. That lien's valid for whatever they owe us from there forward.
No, absolutely not. No. One, we're talking a couple different things. One, whether a lien is on file or not, you can only collect going back 5 years on a debt.
Even if we're doing it, not third party. I thought you said if we were doing it ourselves and it wasn't a third party.
Well, you can demand anything. Anybody can demand anything. The question is, what's the likely response? And if a debt collector is making a demand for a debt that is barred by statute of limitations, the likely response is you violated FDCPA. Now, not only you, debt collector, are liable, but also your client is, and that the underlying debt is gone. So I don't subject my clients to that kind of liability or my firm, and so we don't do that. The association could demand payment on an eight-year debt, whether there's a lien on file or not, and the response from a savvy debtor would be, well, I'm only going to pay 5.
Right. But we don't have to refile a lien after 5 years if they still owe money. It's not valid, or...
But we don't, again, I see people file liens every single year. The better practice is to file one lien when there is a debt owed and have continuing lien language in there that says this lien secures not only the current amount owed, but also future unpaid assessments, interest, cost of collection, and attorney's fees.
That's what I was saying. We just have kept refiling because we thought that was that 5 year, we had to keep saying it was out there. No.
That doesn't do anything as far as the statute of limitations goes. The only thing that stops the statute of limitations is filing a lawsuit. That's what tolls the statute of limitations.
And then we keep billing the owners even after we file liens for all the, everything they owe, right? We just keep, we just send them bills just like everybody else.
Typically, yeah. All right, so that's the collection stuff. The other part of enforcing association assessments, and this gets back to the fines discussion, is all the different kinds of cases. And so this is a picture of bulk trash day that never ends. This is like every day in Luther. I live out in Luther, Oklahoma. This is one of my favorites. These are real photos, by the way. These are not photoshopped. So this actually wasn't an HOA dispute. This was a neighbor dispute where this neighbor had a nice view of the mountains. This neighbor came in and built a roof. The first neighbor sued him, ran up the attorney's fees, and so then these window louvers that look suspiciously like a middle finger go up. I've got another one. I'm trying to cycle these out because I know y'all come back. There was one where wife divorces the husband, and the husband buys the house right next door to the ex-wife and her new husband, and puts up this huge monument, this huge statue of a middle finger that's pointed right at the other house. This is over in the UK, but this is, the parking lot house. And this is where did Craig left. This was a house down in Texas, Waxahachie or something. This is making the rounds. They found, the neighbors found out rather abruptly that they didn't have a covenant that prohibited painted brick or the color of the painted brick. I'm not sure what all the yard art.
The guy even bragged he bought in this neighborhood because they had no covenants. And he wanted to paint Pepto-Bismol pink.
And success, mission accomplished there. This is an association I represent out in Tulsa where the owner got into a scrap with the association and had a brand new decorative planter installed in his front yard, which, of course, I'm the association's attorney. My job is to get rid of this thing, but I thought the guy ought to get a credit for creativity. I thought this was brilliant. And this one, and it's interesting, this one's a new picture. This one's been here since I started doing this a decade or so ago. So this is one of the first covenant enforcement cases I ever litigated as a baby lawyer, and she had her yard art. So what do you do when you get something like that? Well, going back, and I won't belabor the point, but the first thing you do is try to go to your neighbor and have a conversation. And I get it. It's kind of like divorcing couples. She's always crazy and he's always a jerk, right? That's the reason people get divorced. But I get it. There's legitimate reasons, and just like people splitting up, there's legitimate reasons to do that. But oftentimes, having a difficult conversation with your neighbor will resolve the issue. I don't know if it'll necessarily resolve a Pepto-Bismol house. I can tell you it will resolve a toilet planter in the front yard. No amount of discussion was going to resolve this. She was literally nuts. She ended up a couple of years later, after the association got an injunction and got all this cleaned up, she basically kidnapped her. She was going through a divorce. She kidnapped her kids and ended up on that America's Most Wanted show. They arrested her in New York, and I have no idea where she is now. But sometimes you're just talking to a wall. I do get that. So what happens if, going to your neighbor, bringing in a third party to try to resolve the dispute. What if none of that works? Well, then that's why you have court. We talked about the efficiency, the effectiveness of penalties. Maybe you don't have that in your covenants. Maybe you have to file a lawsuit. Well, the lawsuit that you're looking to file to enforce covenants is an injunction action. So you're going to have to convince the judge that there is an enforceable covenant, that there's no other remedy available, meaning there's no money judgment. It's not like a car accident case. So in car accident cases, you're not going to court asking for the judge to order this person to stop running over you with their car. That doesn't make any sense. Just like in covenant cases, you're not asking the court to award money, because what kind of money compensates for that? Well, there's not a scale out there that says if your yard looks like that, everybody in the neighborhood or the association gets awarded $10,000. That just doesn't make sense. So the lawsuit that you are going for is an injunction. Now, sometimes, and by the way, you cannot get an injunction in small claims court. If you're going to small claims court, you only get money. In certain instances, if you need certain property back, you can go to small claims court. So for example, if you're in the instance where your manager or your bookkeeper decides the company file, the company checkbook, all of the company records, they've worked so hard on them that it's actually theirs and they're not going to hand it over to the new person because their feelings are hurt that you fired them. That's when you sue them in replev, it's called replevin, in small claims court. And that happens occasionally. I've had to do that. You remember, did anybody watch the movie or see or read the book, Charles Porter's book, True Grit? Remember when the little girl is yelling and she says, "I'm going to sue you in replevin." She's talking about the horses. That's what she's talking about. It's the same kind of deal. When someone has your personal property and you want the judge to order them to give it back, then you can do replevin. But typically, when we're enforcing covenants, we're talking about a lawsuit for an injunction. Each case is on its own merits, and we could spend an entire night just discussing the ins and outs of injunction lawsuits. If there have been waivers, if we're talking about enforcing use restrictions versus structural restrictions, if you're asking for a prohibitory injunction versus a mandatory, prohibitory meaning, judge, we want you to prohibit them from doing this, and a mandatory is, judge, we want you to order them to tear those non-conforming shingles off their roof. It depends. Depends on what the history of this individual is, if they sought approval, got it, and then it was removed, if they didn't seek approval, if they're doing it out of retaliation. I mean, all of these facts go into how the case is going to be evaluated, all right? And it's going to be an expensive one, and it is an attorney's fees case. So in Oklahoma, if you're going to recover attorney's fees, you either have to have a contract or a statute that allows you to recover attorney's fees. And they're not recoverable in every single case. So if there's property damage in Oklahoma, we have a statute that would allow attorney's fees. If there's personal injury, there typically is not attorney's fees. So if you've ever been involved in a car wreck, and did you notice that the insurance company settled on your car damage just like that? And then they strung you out or hem-hawed or were real hard to work with on your personal injuries? It's because of attorney's fees. Because they're going to get dinged for attorney's fees on the property damage, but they're not on your personal injuries. It's the same analysis, and that's one of the first things that we look at on litigation. Who's going to pay the attorney's fees? I mean, as attorneys, we know our client's going to pay them, otherwise we're not going to represent them in court. That's just what attorneys do. But ultimately, who is going to pay the prevailing party attorney's fees? So the answer in our context for most associations is there are prevailing party attorney's fees statutes If you're a homeowners association, condo association, the statute does not provide for prevailing party attorney's fees. So you've got to look in your declaration. If you're a condo association, it's got to be spelled out in your condo docs. Homeowners association, you probably have the ability to collect attorney's fees. But you're going to want to see, does the association hold title to the common area? Because our statute provides that any person, and your corporate association is considered a person under the way person's defined in the law, any person holding property within the addition, and common area counts as property within the addition, or if the declaration otherwise provides that the association can sue and enforce the covenants and collect attorney's fees. So that's a big issue. It's a big thing to know prior to filing the lawsuit. Your attorney better know it before they go into court, who has the ability to collect prevailing party attorney's fees. This last one, declaratory actions. So sometimes we have disagreements. We're not necessarily in a knockdown, drag out fight. We have perhaps language in our covenants that doesn't make sense. And it seems to make sense to this person applied this way, and seems to make sense to the association or another person this way, and we just can't resolve it. Well, one way to resolve it would be to take that dispute to court with a declaratory action. And what you're asking the court is to declare how that language should be interpreted. Okay? Again, you're in court, you have lawyers, and you're spending money. There is a better way to handle that, and that's with association or covenant amendments. Now, I use this slide as an illustration of why we should amend our covenants sometimes. I want you to read this and see if you find anything wrong with it.
Are they saying only cripples can shoot, or you can only shoot cripples?
So only handicapped people, if we're talking about, sometimes cripple is used. So it can be interpreted either way, I guess. Then only if the boat is moving backwards or sideways, apparently. The boat shall not be in forward motion. Anybody know what this is talking about? This is actual language, down to the punctuation. It's horrible. It's beautiful and horrible, just like Facebook. Anybody know what it's talking about? Tom, don't answer. Hunting. Yeah, shooting birds while they're crippled on the water. So this is actually a sportsman covenant, an attempt at a sportsman covenant. So no shooting ducks. You gotta shoot them in the air, unless they're wounded, and then you're putting them out of their misery. So this is a hunting community, sportsman community, and they've got very poorly drafted covenants. So let's talk about amending the covenants, and I'll walk you through. I'm not going to go line by line, but this is where our terminology is really important. So if we're amending covenants, then we're going to follow one process. If we're amending bylaws or articles of incorporation, we're going to follow a different process. And they're completely different sections of law, right? So if we're amending bylaws, then where we're going to start is looking in the articles of incorporation. And it seems weird. Why would we start in the articles of incorporation if we're going to amend bylaws? Because the way Oklahoma law is written, if the articles of incorporation don't restrict or prohibit the board from amending bylaws, then the board itself can amend the bylaws. And this is even if we have bylaws that say, under no circumstances can the board amend the bylaws unless the articles restrict it, the board can amend them. This is Title 18, Section 1013. Okay? Now, I said can, not necessarily advisable, and I'll get to the advisability of different amendments in just a second. We're talking about mechanics. So you look at the Articles of Incorporation, you can certainly follow the bylaw amendment clause, and if the bylaws don't have an amendment clause, then certainly the Articles of Incorporation, or hopefully the Articles of Incorporation, don't restrict, and you can amend with just a board vote. All right? So that's Title 18, Section 1013. Well, what if we want to amend the covenants? Well, you can't use Title 18, Section 1013, because it doesn't apply. What you use, unless you're a condo, so our condo lady back there, you got to close your ears for just a second. 106.1 that I reference up here, this 11 OS 42-106.1, that's only for homeowner association type covenants. They don't apply to condominium. And the reason 106.1 doesn't apply to condominiums is because if you read 106.1, it talks about calculating the percentage vote based on lots. And then it references a preliminary plat. Well, condos don't have plats. Condos don't have lots, they have units. So I am aware of some lawyers that think you can use 106.1. I'm just not in that camp. I don't think you can. So if you look at 106.1, what it says is if your covenants don't have any amendment clause, or if your covenants have been on file for at least 10 years, then you can amend with a 70% by the owners of 70% of the lots. Okay? The percentage is taken of the lots, not of the owners. And if your covenants have been on file for 15 years, then you can amend with the owners of 60% of the lots. So it's basically if you don't have an amendment clause in your covenants, or if your covenants are sufficiently old, then you get these percentages. And this is important because if you look at different covenant clauses, covenant amendment clauses, they're drafted in such a way, and there was the popular form, in fact, I still see this pretty commonly. The amendment clause will say something like, these covenants shall run for 10 years, at which time they will automatically extend for another 10 years unless then modified by percentage of the owners. Well, what that means is our covenants during those restrictive periods, you have to amend with 100% approval. In other words, you're never going to amend these during our restrictive periods. Well, when can we? You can do it on that one day when it says, and we have a court case, it's out of Garfield County, that says, well, what does at which time mean but that one day? And the court also says, by the way, if husband and wife own the lot, you both have to sign. One can't sign for the other. I get that. I agree with that. I also agree linguistically with the at which time. I mean, they are right. It makes sense. It doesn't mean anything if you can amend at any time. Well, unfortunately, a lot of those clauses, what they say is, these covenants shall run until January 1st, 2020, at which time they will automatically extend unless amended. Well, guess which courthouse is open on January 1st of every year? None of them. What do you do with that? Oh, I don't know. We don't have a court case that says what you do with that. I can tell you what we do, and we take our vote beforehand, and we include a lot of language that says, we're taking our vote now because the courthouse is closed on January 1st. We file it on December 31st, and these are going to magically spring into life on the 1st when the courthouse is closed, and then that's what we do. But you don't have to do that. You know, you can just file covenants that have an amendment clause that makes it easy, at least mentally, from a procedure standpoint, on how you amend them. But if you find yourself with a really poorly drafted amendment clause, then you can use 106.1 to amend. All right, let's talk about condos for just a second. So condos, and this sometimes will apply to homeowners association type covenants as well. It's not that uncommon in condo amendment clauses that there's language in there that if you're going to do something, that's something typically modifying common elements. If you're going to add a common element or if you're going to change the common elements, then you not only have to get a higher percentage than regular, but you may also have to get all mortgage company approvals. So that
would be stated in the...
it will be stated in the amendment clause. That's right. So what you have with condos is sometimes this staging of amendment. All amendments require simple majority, except in the event of changing the definition or the items of common elements, and then you have to get 75% and possibly mortgage company approval. Except if you're changing the common element undivided ratios, so each unit owner has 1.75% undivided ratio of the common elements, and I'm just making that number up. There's going to be an exhibit to the declaration that has unit numbers and then a percentage next to it. That's the undivided common element ratio. If you're tinkering with that, it requires 100%, and that's by statute. So with condos, it's a little bit more complicated. So where that comes in is association gets notice that their insurance is going through the roof, and it's probably because of the roof in Oklahoma and wind damage. And so what they decide is, okay, well, we're just not going to insure roofs anymore, except the declaration requires the association to insure the roof because it's a general common element. Okay, well, we just won't make it a general common element anymore. Well, if you're going to do that, a lot of condo docs require higher majority mortgage company approval, and those votes don't pass. So we have to be careful. We know what we're doing when we're wanting to tinker with the condo docs.
In talking about the condo owners have to get a specific type of insurance because the association covers the roof rather than the owners.
I thought I had it on here, but I don't. Just for time's sake, I'm going to go ahead and switch to insurance. So, and I don't have it on here, and I really should, now that I think about it. So in a condo setting, the association owns, in fact, I'm going to get to draw tonight. I didn't think I was going to.
Neither did I.
All right, this is our happy condo acres. And this is a shared wall firewall. This is our shared wall townhome. Sometimes when people use the term condo, they're talking about a type of building. But I can tell you that other than this is a solid line and I squiggled that, that's not any distinction. The structures can be the exact same, okay? And we call one a townhome, the other one we're going to call a condo. So typically the insurance that we will get for a condo, and now I'm going to so if that's the front door, and you've got different rooms in here, hallways and stuff. So if this is, we're looking down, this is the elevation, right? So the association, typically with condo, they're going to insure and own the roof. And the association's going to own, I'll just hatch this part. The association's going to own the foundation, the walls, the structure. If this is say this is a supporting wall, the covenants may require that the association insure that. But typically, the unit owner owns from the wall finish in, and from the floor finish up, and from the ceiling finish down. They own not just the airspace, but the coverings, the finishes. Oftentimes, the covenants will go and describe the fixtures. Hopefully, they have thought through, okay, the plumbing that runs through the walls is the associations, but at what point does it become the unit owners? That's a big deal in condos, is, you know, the leaking water pipe. It's a nonstop fight. Or the leaking roof. Water issues in a condo is a big deal. So the association buys what's called a blanket policy. Sometimes they'll buy what's called an all-in policy. And what the unit owner gets is what's called an HO6 policy. That's what you're referring to. Now, if you own a condo unit, you want to have an HO6 policy, because that's what's going to fix all of your stuff. It's going to replace your stuff. It's going to replace the carpet. If you don't have an HO6, what you're going to have is an unfinished space with no toilets, no sink, definitely no refrigerator, none of your clothes. You will have an unfinished box that the association replaces, or the association's insurance replaces if this gets destroyed. All right? So an HO6 will provide your contents. One other thing that your HO6 should have, and you want to make sure it has, is a loss assessment clause. A loss assessment. What that's going to do, say the way the association's insurance is written, say it's a $10,000 deductible per building. And the condo docs say the deductible is assessable against each building. Well, who has 5K laying around? Your loss assessment does. That's what it's for, is to pay that portion of the deductible. HOA?
In those cases, though, there's a certain amount of loss assessment that's automatically included in an HO6. So people have to know what their assessments are going to be. You can get that limit raised at your own expense, but you have to know the maximum amount of assessment you're going to be charged.
That's right. That's why being somewhat informed on, particularly on the condo association insurance deductible, because it can be a whopper. It's not the same product that you have for your single family house. And knowing, is that deductible assessed against a building, or is that, the association wide? If it's association wide, but it's $10,000 per building, and you have one building, then that's spread out over the entire development. But if you have half a dozen buildings, now you have half a dozen deductibles. So running those numbers and knowing ahead of time, and again, either having a reserve, having adequate insurance, it's just asking those questions ahead of time. On HOAs, it's a little bit more complicated, because you want to make sure that the declaration is drafted in a way that matches the structure. So the worst case would be the unit or the lot owners believe that the association has insurance for the roof, and they buy a tenant's policy. or they buy an HO6 policy. And the association, all they insure is the clubhouse over here. You know, that's a really bad day, but that's not unheard of. Or the association buys some limited policy or some mismatched policy that doesn't match what the declaration requires them to. Well, now, if there is ultimately a claim and a gap in the insurance, that's when you see people hire lawyers and file breach of fiduciary duty claims. And so making sure that the declaration language matches, because it's not uncommon where you have a single family homeowner association development and the covenants read just like a condo doc and require the maintenance level of a condo doc, but you don't have the adequate provisions typically with utilities. Because very rarely, if you have a non-condo dock for a structure like this, and you have a shared meter box, or the association has the control of the meter, do you have an allocation in the covenants of, okay, at what point does this owner become responsible for the line? So if you, and the question is, if this is water and the association is required to provide utilities, water, electricity, to the unit owner, at what point does the unit owner become responsible for that line? Is it the one that just feeds their unit? Is it from here, if this is the end of the line and it goes to those units? That we need that language to be answered in our covenants, because the statute doesn't answer it. Okay? So asking those questions, and that's a little bit of a rabbit trail, it's not insurance, but it's typically included. Because when something like this happens, when this guy plants a tree and then the tree falls, the result in an HOA depends on the covenant language, and the same in the condo association. You know, typically the condo association controls the exterior. This is general common element, unless this is a courtyard, and in the courtyard it's a limited common element and the association allowed them to plant the tree. Well, if we have limited common elements, what does the association's insurance policy do with that versus the individual owners? All right, so the questions of liability and who covers what in what instance, it's part and parcel with insurance, and making sure that the insurance policy covers the expected result. Okay. I'll mention duty to defend. So one of the reasons we place policies, it's not just to get coverage in the instances when we expect it, but it's also to provide us a defense, particularly with the D&O. And when I say D&O, I'm talking about directors and officers. Sometimes people will say errors and omissions, but this is the policy that covers the directors, the officers, sometimes the managers, the agents like lawyers, committee members, architectural committee members. All of those folks may fall under the association's officers policy. The big thing here is the duty to defend, because what happens is individual gets threatened by the board, or someone brings an action against an individual for violating the covenants. One of those trashy houses or one of those pictures that we saw. And the individual says, or they get a lawyer that thinks they're crafty and says, you know, I heard somewhere that the best defense is a strong offense, so we're just going to turn around and sue the board. Well, we talked about last week, the reason why we operate as corporations is so that we're not personally liable. And in very few instances that I actually see in my practice are board members proper parties to a lawsuit, okay? I mean, you have to act outside of the scope of your duty as a board member. You have to do something that is grossly negligent or intentionally wrong. You know, did you embezzle money? Did you not follow the advice of the CPA or the lawyer? Those may incur individual liability. The fact that the board member made a decision and that decision isn't liked by the defendant, well, that's not personal liability, okay? But anybody can find a lawyer. Anybody can convince that lawyer to file a lawsuit. That's just the reality of our justice system. And so what the duty to defend does is when that happens, your insurance company should hire the lawyer to defend the association and the lawyer to defend the individual board members. Okay? So, for example, I've got a case. It's a neighborhood in Edmond. The last buildable lot in that neighborhood hired by a lady or bought by a lady. She hired a builder, he fired her. She hired another builder, he fired her. She decided she's going to move forward with the plan that she wanted. After many, many hours and on-site meetings, meeting with her architectural committee, said, you are not going to build that house. This is a fully built out neighborhood. It's country French. If you've ever driven through Edmond, you know what the house looks like. And she was not building that house. She says, couldn't care less what you say, I'm building it anyway. So the association filed a prohibitory injunction lawsuit against her. And she turned around and sued every single individual architectural committee member and counterclaimed against the association. So now at this point, the architectural committee has their lawyer. State Farm hired me to represent the association, and the association's legal expenses, at least in the defense of the lawsuit, and those architectural committee members' defense is all covered by insurance. That's the right result in that case. So that is why knowing what is the scope or the extent of the duty to defend clause in your association's policy is important. One other thing, and I don't have this on the slide, is knowing what the terms are for settlement. And the way this works is some insurance policies require the insured to agree to settlement. And this isn't, in the grand scheme of things, this isn't that big of a deal. Having been on the receiving end of what I think is a frivolous lawsuit, it became a really big deal on whether I get a say, do we settle with this party? It's very easy to find a lawyer to sue somebody in this country. And sometimes it happens for business tactics. Sometimes it happens because adults have money and throw tantrums. Sometimes it happens for legitimate reasons. But knowing whether you get a say as the insured, do you get to settle on your terms, or does the association's insurer decide when they settle? Because I guarantee you, your interests and your principles are not necessarily the same, okay? You may not settle as a matter of principle. You may not settle to avoid awarding bad behavior. Your insurer's settling because they want to save some of the reserve. They want to offer $5,000 as nuisance value, even though you think they should pay nothing. So knowing what the terms of settlement are and whether they have to have permission, that is a thing, and you may want to know that when you're placing your policy. Any questions on insurance? All right, got a little bit of time left. I want to cover A little bit of board duties and operations, and we've covered some of these. I already mentioned shall. As a board member, you need to be familiar with your governing documents, and as you come across them, or as you read them, if you come across the word shall, you need to circle it and highlight it because that's something you can't ignore. Now, I'm going to give you an example of, I'm not going to tell you to ignore it, but it's something out there and y'all have to figure out what to do with it. So sometimes you'll come across the language in your bylaws that says on an annual basis, the board shall conduct a certified audit. Well, has anybody priced what a certified audit costs these days? So I come across association clients, you know, they're 20, 30 unit condo developments. They've got a budget of, 30 grand. Well, a certified audit is going to cost 10 grand. Why in the world would anybody spend a third of their budget to make sure the other 2/3 was being spent appropriately? It doesn't make sense. But there it is. What do you do with it? Well, you amend it out. That goes to the top of the list to amend. Well, what if you can't get it amended out? What do you do then? Well, again, you're caught with this mandatory obligation, and yet it's a horrible decision. It's where, if you've heard the phrase that something typically referring to the Constitution, that it's not a suicide pact, that we're not going to interpret language that drives us over a cliff. You may take that approach with that audit language. And there's ways to ensure that the money's being spent appropriately. You can have a CPA do a review, which is less expensive than an audit. Have some kind of third party do a reconciliation of all the bank statements, and that kind of dovetails into some of these other things. So one of the best ways, and we talk about this in our embezzlement or anti-embezzlement and fraud workshop that we do, one of the best ways to avoid getting taken by treasurer, secretary, board members, manager, attorneys, anybody, is by having regular board meetings, and at those board meetings looking at reconciled bank statements. Okay? Not an Excel spreadsheet that your manager prepared, not a handwritten, here's how much we have in the bank, okay, looks good to us. A reconciled bank statement. Because it's very, very hard to forge that, right? And you actually have to look at the bank statements and look at the checks that are being written. And what a reconciliation does is it takes the accounting system or software and compares it on a monthly basis to the actual in and out, and the result is a report. And the report's going to show you all the ins and outs and all the outstanding checks that haven't cleared. All right, well, what's all of this, what are these outstanding checks for cash that are showing up? Or why are we spending all of this money with this management or this vendor that I've never heard of? What is this for? And having the opportunity to ask questions about the finance, that's the board's purpose. And in virtually every single instance, unless it's a strong arm robbery, embezzlement is done because other people aren't paying attention. Okay? Embezzlement, most of the time with associations, it's like leaving your phone on your dashboard and not locking your car. Really? Okay, I'll just take that for you. Okay. So we can protect against that by having some basic practices. So the business judgment rule, in order to manage corporate governance and the armchair quarterbacks or backseat drivers that typically corporations have, all of the nitpickers, the naysayers, and second guessers, we have the business judgment rule. And what the business judgment rule says is, look, just because the board gets a decision wrong, or what many would consider wrong, doesn't mean it was a wrong decision. if it falls within the business judgment rule, and did they reasonably rely on the facts available to them? Is there an absence of self-dealing or these other things that we look at to give an indication that something is not on the up and up? Well, we're going to say it's the business judgment rule, and the court's not going to second guess the board's decision. All right? So, board wants to put in a playground, they contact several contractors, they get references, they look at Facebook and Google reviews, and they make a decision based on all of that information. And it turns out this is quite possibly one of the worst playground installers in Oklahoma City. Business judgment rule. The board members are not personally liable for making a bad decision, okay? Because if they were, who would serve on the board? So we protect our board members with that. Duty of loyalty, this doesn't come up that much, but where I see it is where, say there's a board, I'll give you an example. So I met with an association, there's a roof shingle issue, and the question is whether the board is going to, what kind of action the board's going to take regarding this non-conforming shingle. And I meet with the board, and I go back to my office, and a day or so later I get an email from the individual with the non-conforming shingle, and the email contains information. The only way they could have known is if they were sitting in the room when I was meeting with the board, or one of the board members communicated that information to them, despite the fact that I typically will advise my clients, hey folks, if you run and tell the defendant what we talk about here tonight, that's a violation of attorney-client privilege. That is a textbook breach of your duty of loyalty. If you can't keep your hand over your mouth, if you absolutely have to communicate what you hear, then you can't be a board member. You should do the not honorable, but the rightful thing, the thing that keeps you from violating your duty of loyalty, and step out of the room and don't participate or resign from the board. Okay, breaches of duty of loyalty, it erodes the confidence that other board members have, and it creates this suspicious, untruthful, I can't rely on anybody, in this faction among a board, and it's corrosive. When I serve on a board, I have to know that everyone else has my back, just like I have their back. That if we make a decision, when we leave, we're all going to be in lockstep. Otherwise, it's every man and woman fighting and politicking, and it's everything that we hate about Washington, but it's where we live. That's why the duty of loyalty is so important. Self-dealing, that's a no-brainer. You find out that the association's about to buy a piece of property or wants to buy a piece of property, and you know this because you're on the board, and you run out and you buy that piece of property so that you can sell it to the association at a profit. That is self-dealing. Self-dealing is also if you set up a dummy company and have your brother-in-law, who nobody knows is your brother-in-law, pitch this idea to the association, and they don't get the value and they're paying the money. That's self-dealing as well. All right. Arbitrary and capricious, this goes back to previously when I mentioned the hypothetical about picking the winners and the losers with collections cases. It's the same thing with covenant enforcement. We can't treat people who are similarly situated differently. That's arbitrary and capricious. So if y'all have been in the business of handing out exemptions for chain link fences, you don't get to stop it just because you don't like this person. That's arbitrary and capricious. Okay. Yes, ma'am.
Question, how do you actually enforce something like that? Say you got an RV parked in a driveway, and you told them that's against the covenant. You'd ask them to move it. I mean, is the only way to actually end up going to file a lawsuit against them because we don't have any fees or charges or Nothing in the
Well,
covenant.
if you don't have a fine schedule, then, and you have followed the course of asking them and they've refused, then yeah, the next step is a lawsuit for an injunction.
That's it.
And I may have mentioned this, I did mention, the likelihood of success or how that case is evaluated depends on a number of factors. It does seem to be easier to get injunctions for transient type violations, RVs parked there. It's easier for the court to say, move it, move the trailer, don't park it there, as opposed to, you've got to tear down that sunroom. If it's a structure, a shed, add-on, I have found it's difficult to get the tear down. It's not the same for roofing covenants though. Judges don't seem to have the problem tearing off roofs, and I don't know why. I need to do a survey and see if it's kind of the same thing in other states. It may be because roofs don't last long in Oklahoma, and so they're just like a parked RV. It's, here one day and gone the next, so that may be it.
So is that where they're responsible for attorney's fees? If you win that in court, they have to pay the attorney's fees?
Here you go, it depends. It depends on if everything that I said about attorney's fees, it's the same now. Okay, 1027E and 865, and I'll end on this because this is important. So if you go to OSCN, and I would encourage you to look at this, 18 OS 865 through 867, and what you're going to find is some language that it doesn't require it, but this 865 provides that if your association files a certain kind of tax return, and surprise, your association does have to file a tax return. If it's a corporate entity, it's taking money, may not have any taxable income, but it has to file a tax return. And while you're at it, you might as well file the one that 865 provides, and that's an 1120H. 1120H. And it applies to whether you're an HOA or whether you're a condo, provided it's a residential association. I don't think anybody's here on a commercial condo or commercial association. I don't think I've ever asked that question before. It never occurred to me that somebody would be. But 1120H is the return that residential, condominium, and homeowner associations file. It's a very simple form to fill out. It's got one page of instructions. You file it on an annual basis. And what that does, if your association files that, what it does is it provides certain different levels of indemnification immunity for your board members. What it does is it gets rid of joint and several liability, which means if I'm on a board, I'm only going to be held personally responsible for my bad acts or my wrongdoing. I'm not going to be held jointly and severally liable with somebody else, okay? And that's a big deal. It also ramps up the standard of negligence. If I'm going to be personally liable, my level of negligence has to be grossly negligent. Not simple negligence, like I accidentally backed into you with my car. That's simply simple negligence. It's, I saw you there, I didn't think twice about it, and I floored it. Okay? Almost, gross negligence is almost an intentionally, criminal, wrong type of act. All right? So then we have 1027E, and this is really the golden language, because what we have here is an immunity. An immunity it's just the invisible force field that protects you. It just deflects everything. So what this provides is, if you in good faith as a board member rely on a professional opinion, landscape architect, is this a good retaining wall design, and will you oversee construction? Yes. Will you find the subcontractor? Sure. They do that, the wall falls down, guess who's liable? Not the individual board member, they relied on a professional, okay? That's how 1027E works. Where the individual board member is going to have a problem is, and this happens sometimes, and I get it, I think it may happen with good intentions, where the board needs the retaining wall, landscape architect says, sure, I'll give you a plan, and sure, I'll oversee it, and that'll be $10,000, and one board member says, I could build that for $3,000, and the rest of the board says, sounds like a deal to us, and guess what, it falls down. Well, you've ignored the advice or not relied on a professional. You went on budget. And so in that instance, 1027E isn't going to apply. One other thing, and then we'll call it a night. It says this matters the member reasonably believes are within that person's competence. So it doesn't work if you come to me, the lawyer, and say, hey, can you oversee building this retaining wall, and we'll pay you for you to do that? It's not reasonable to rely on my advice on a retaining wall, although I could build a very good retaining wall. But that's probably not reasonable. You know, you have to ask and seek and rely on the advice within the competence of that person, okay? So that's part two. We cover a lot at a fairly high level. Like I said, I don't know the time frame, but the goal for me and Craig is to get the HOA Condo Learning website up and running, hopefully within a couple of months. And so, and we do provide this course 2 more times this year?
Yes.
Is it 2? Okay. The slides are going to be roughly the same, but if you'd like to come back and join us again, you're more than welcome. So thank you guys for being here.